Welcome, class. I think I finally got YouTube worked out here. I will briefly go over the PowerPoints that I have set up in case people cannot attend the seminar. Then you'll have these PowerPoints to go by. Also, please feel free to contact me if you have any questions. And I'm sorry for looking down, but I'm trying to look at the video, or my PowerPoint, presentation as I do this video. To start off, let's review. We've had our midterm, which was our answer. You guys did the interrogatories last week for Unit 6. You did a great job. Most of them have, when I say most of them, I can't really think of one that was not, when I say good. Some of them may have had some minor issues, but again, nobody was like way off the mark. So you guys are doing a good job with that. This week and last week are things that we call discovery. I wanted to share that because that's the broad overview. Discovery itself can then be broken down into several areas. Interrogatories, which is what you guys did last week, is again considered discovery. Discovery basically is an opportunity for each side to try to obtain additional information about the case. So, like you said, with interrogatories, you're asking questions and you're trying to solicit more information. On the request for productions, you're doing just what the name says. You're requesting something. You want something physical, something tangible. For example, using our record company as a defendant. You know, if you're suing them, then naturally one of the things you might want to ask for is the contract. Your interrogatory would be, do you have a contract? The request for production would be, please produce a copy, or please give us a copy of that contract. So again, that's kind of what we're doing this week, is doing the request for productions. So I just wanted to make sure that you guys knew the distinction and understood what all of that was about. Other types of discovery, which we have not discussed, but which are in the slides, are things such as depositions. And a deposition is an out-of-court statement taken under oath. Generally, you conduct depositions in your office, meaning, for example, if I represent Justin King and I'm representing the plaintiff, then Justin's attorney is going to want to do the depositions at his office. Conversely, if I'm representing one of the defendants, I would like to do the depositions at my office. There are times and situations where you can't do it at your office. But before I get into that, let me explain why you want to do it at your office. You want the other person to feel uncomfortable. In other words, Justin goes to see his attorney or speaks to the paralegal all the time, so he's comfortable there. But if he comes to my office, he doesn't know what my office looks like. He probably didn't know what I look like unless he's been showing up at some of the hearings, or because maybe we filed some motions or some things. But still, though, I don't represent him, so he's not as comfortable with me. So it's kind of to put the person off their game. Now, like I said, there may be times where that can't happen. For example, I was working with another attorney. Brief overview. Our client, lights had gotten cut off, he says wrongfully. He got injured basically while the lights were off, like he slipped and fell, and it was late evening. And he was saying that because the power company had wrongfully turned his lights off, that he should be compensated for his medical expenses, etc. Well, so some of the people that we wanted to depose still work for the company, but they have been promoted. So, you know, you guys know I live in Mobile, which is like lower Alabama. And the power company is headquartered in Birmingham. So that's about 3.5 hours from where I live. So again, some of these people have been promoted and they were at the corporate office now. So we had to conduct depositions where they were. You know, the company wasn't going to pay for them to come back down. We had to pay to go up to Birmingham. Fortunately, the guy that I was working with on this case had a friend up in Birmingham who had a law office, so that person allowed us to share to utilize their office space in order to conduct the deposition. So again, you kind of tend to want to make it, when I say uncomfortable, a place that they're not familiar with. If push had come to shove, we may have been forced to have it at Alabama Power. That's the company we were suing. Like if they had a conference room and they had offered that, and if my friend didn't have a friend in Birmingham, he may have been forced to do that. But you really kind of want to make it somewhere that the person that's being deposed is not familiar with. Now, notice I stated that it is an out-of-court statement made under oath. What I mean by that is you have a court reporter. You guys watch TV, and I think most of the time when we see a court reporter, we think about TV where they're in the courtroom and taking down what people say. Where there are what they call roaming or independent court reporters for just this type of situation, for a deposition. So they're willing to come to your office to then take the depo. They charge a fee, of course, but you don't have to pay until after they've transcribed everything. But the court reporter will then put the person under oath, again using Justin King as our example. Let's just say Justin is being deposed. He'd have to raise his hand just like he was in court and swear to tell the truth and understand that this information is under oath. And then a deposition is different from court because you are allowed to ask questions that are not admissible in court. Excuse me. You can ask the questions, but the other side still has a right to object. Meaning, if my question is, did you discuss this case with anybody? And let's just say Justin King says, yes, I talked to my lawyer. I have to stop there. I can't get into privileged information. That's covered. So what I'm saying is if the other attorney tried to go and ask, hey, what did you tell your lawyer? Then as their attorney, I can step in and say, hey, I object on the grounds that this information is privileged. My client still would be, I say, forced to answer, but I have it on the record. And then when we get ready to go to court, if they try to introduce that, I can say, Your Honor, I made an objection at the deposition. This is important because the attorney can't make an objection later. So I just want to make sure, even though you guys aren't the attorney, I kind of want you to understand the procedure, because the attorney may ask you to draft some of the questions to help them get prepared and get started. Meaning, they may have 10 or 20 questions they start with, and then kind of going back to what we discussed before about how you prepare a client for a deposition. You want to make sure your client doesn't say something that might trigger something to say, okay, I would just have these 10 questions, but now that you answered this way, this has opened up some doors where now I want to ask some additional questions. So anyway, again, as the paralegals, you all may be called upon to say, like you say, draft 15 or 20 questions that you think I should at least start out with. And then, like I said, as the deposition goes along, the attorney may think of some additional questions. Defense attorneys tend to ask a lot because they're getting paid by the hour. So it's just true. It's just a true statement. But I want to make sure you understand the significance of the objection. You have to make the objection when the question is originally asked. So again, looking at it from the other side, if you don't object at the deposition, it tries to get read in, and you never objected, you could lose your objection. Technically, I think most judges on a situation like that where it's privileged and everybody's heard of that and knows about that, you probably wouldn't have an issue. But if you had another question like, I know in some of y'all's interrogatories you may have said, please tell us your driving history for the last 10 years, or please tell us if you filed a lawsuit in the last 10 years. And I kind of made a note. I didn't take off points, but I was just notating, be careful, because each jurisdiction is different. Maybe some jurisdictions will have a 3-year limit, like you can only ask for things 3 years. For example, in Alabama, for tax returns, you can only go 3 years back. So going back to our scenario, if Justin was being deposed and asked something like, what's your driving history for the last 10 years, and let's just say in your state, again, the person can only go back 3. The attorney needs to make the objection at the deposition. Otherwise, that could be something where they'd be like, well, you didn't object at the deposition, so I'm going to let it in. And again, you guys as paralegals wouldn't get into that as much as, again, I just kind of wanted to let you know that if you're asked to draft the questions, you need to kind of keep in mind, as I stated before, you can't ask what somebody told their priest. That's privilege. You can't ask somebody what they told their spouse if it's a criminal case. Now, civil, there is no such thing as spousal privilege in a civil case. It's criminal that protects you in. So, and kind of the same thing with the whole priest thing. We hear that all the time, but that's in a criminal case. Usually in a civil case like an auto accident, those privileges don't exist because you're not, the only thing you're going to hurt, you're going to be out of money. In a criminal case, you could be losing your life, like if it's a capital case or something like that, where they're looking at the death penalty. So that's why they make the distinction there. But your attorney-client privilege is always there, whether it's a criminal case or a civil case. So that's why I used the attorney-client privilege the first time. And again, I'm looking at my notes, so forgive me. Just to make sure you understand some of the terminology. When you depose someone, that means you're conducting a deposition, which, like I said, is an out-of-court statement made under oath. Oh, another thing, the reason that, again, that this is significant is because, as I stated, the court reporter is going to swear you in and ask you, do you understand you're giving this information under oath? Because, as I stated, if one of the parties or one of their witnesses or a doctor or somebody, because let's just say Justin has the ER doctor come in and talk about how injured he was, etc., and if that person says something that's contrary to your case, that can be read into the record because it was given under oath. And like you said, the other side has a right to ask questions and cross-examine, but it's not quite a trial. In other words, the other attorney can kind of come back and you may want to ask some quick questions to shore up some things. But like you said, you don't get into like a full-fledged trial. But again, I guess my basic point is to make sure that you understand that what you're saying is being under oath. Because again, let's just say Justin gets in and he flubs the deposition. When they ask him, well, were you hurt real bad? He say, no, I was a little sore. And then, you try to get the case dropped or dismissed, or we're at trial, and then he's talking about, oh, my back was broken and I couldn't work for 20 days. And they're going to be like, well, at the deposition, look at your deposition, page 12, question 1, or whatever. Do you see where I asked you, were you hurt really bad at the accident? Could you read your response for the jury? And then all of a sudden he says, no, I was a little sore, but now we're at trial. So that's why I wanted to make sure that you all understood that those things can come back to bite you, and they're very important. Another thing that you need to understand, I talked about the court reporter and the fact that they take your information down like we see on TV, and then they transcribe it. Some jurisdictions allow video and audio tapes. Alabama's not one. I know you guys are in different states, but my point is just because the PowerPoint shows or discusses audio tape and videotape, you need to check your state. Not every state allows that. And I know that the book deals a lot with federal court, and that's great, but I also know that most of y'all probably will be practicing in state court more than federal, so that's why I keep stressing to make sure that you guys know to, like I say, check the information for your state. One other slide talks about that only the attorney should ask the questions during the deposition, but again, you never know. Your attorney may have you there, even though you're going to get a copy of the transcript. They may say, well, if you hear something important, they want you to take that note right then, because it may take the court reporter a week or two to get the transcripts to you. And let's just say, again, using Justin King, Justin's being deposed this week. Next week, you guys plan on deposing the hospital or the doctor or the agent, Justin's agent, or like you say, if you're suing MCI Records, the record company or whatever. And let's just say you're not going to have those transcripts quickly enough to be able to look at them yourself. You may want, your attorney may ask you to come as a paralegal to take some quick notes on some things that they think that are important or said. Again, you won't have it word for word, but you'll have a general idea, and that'll give you an idea of some questions to start developing for your side. The other thing is as I stated, let's just say you're going to depose the other side. Let's just say you're going to have a month rather than a week to get ready. Like I said, by then the court reporter has probably transcribed the tapes. So then it will be your job to transcribe the transcription. You'll get a little booklet, and it'll have all the questions. A lot of court reporters also offer what's called a travel size, which basically means they condense it, and maybe you can get 4 or 5 pages worth of information. I'll say 3 or 4 pages worth of information on one sheet. And they call it a travel size because, just like I mentioned before, sometimes you have to go to the other side. You have to go visit somebody. It could be an expert witness maybe. And like you said, if they or working in Bermuda or something and say, hey, I'm going to charge you more per hour for me to have to travel there than you would charge your client as the attorney to go and depose that person. So that, like I said, they'll do a condensed version so that if the original deposition was 30 pages, maybe they can get it down to 10 or 15. And so, like you say, that's something you can have on your carry-on. When I say you, the attorney, and they're looking through it, and like I say, they're prepping. But again, I share that you may get the transcripts because, again, that may be your job to go through and, as I stated, pull out information that you think is important. There's some general questions that most attorneys ask. Please state your name. Where do you live? How many relatives do you have? Do any of your relatives live here? A lot of people ask, why do they do that? I've heard different reasons. One reason I heard was you're just trying to check to make sure that if a person maybe has a cousin or somebody and they don't have the same last name, that person doesn't try to sneak onto the jury. So I make that person list every relative known to man. And when I say every relative, you may ask, well, who lives here? And if the person says, I have a grandmother, an aunt, a cousin, then they ask for every name of everybody who lives here, not people who live out of town. I think it's more of a tactic. And also, when you ask that question, it's more of a tactic. I tend to ask it up front so people feel comfortable. Some attorneys wait and save it towards the end. Now, like I said, it's a strategy either way. Some people ask it in the beginning because, again, you're hoping that the person that you're deposing, meaning the other side, or maybe even one of their witnesses. Like if you're deposing the doctor and, right now the doctor's report seems to be in favor of Justin, but you're hoping to catch him or her in something or get them to admit that, hey, that was just a preliminary scan versus after they've done their, whole research and had, thoroughly checked the patient out type deal. And then maybe they had a different conclusion, but it's buried like in the back of the report. So you're trying to ease them in. Doctors, police officers, a lot of times have had bad experiences with lawyers, and so they tend to be kind of defensive. So as I stated, sometimes as a strategy, you want to make them feel comfortable, and you just ask easy things like, please state your name, where do you work, how long have you been working, do you like your job, just some basic stuff. And then you start getting into the hardball stuff because you're hoping that they'll feel comfortable, and when you start asking questions, they'll just freely give you information. And that's why I say a lot of people do those videos or either have clients come in and do that prep like we discussed last week so that the client doesn't reveal too much information. Again, on the other end, some people like to seem tough as nails because, as I stated, let's just say you're deposing Justin King. And so your client, if you're MCI, if you're the hospital, whoever is suing, you have a right to have, your client has a right to be there as well. So some defense attorneys want to seem like they're tough as nails, and so they want to come in and play hardball. And so, my attorney was strong, and they came right in and they start asking them all these questions, and this guy got flustered and he couldn't answer, blah, blah, blah. And then towards the end, they kind of ease up because, like, we're getting to the end. This person is already not going to like me. That's not a personal problem. I really could care less. But, you don't want it to be a situation where this person is so angry and now, you're afraid they're going to slash your tire or shoot you, do whatever. So now even though they don't like the questioning, by the time you get through, you kind of calm them down a little bit. It's like, okay, they're asking me about my family. They're asking me. Like I said, I guess because I've always seen it done the other way first, and I just tend to prefer that method myself. That's what I do. There's requests for admissions is another type of discovery. We're going to do that, but we're going to do it in Unit 8, and it's not going to be an assignment. You guys are going to get different motions and things that you will do, and we'll draft it in the discussion board. But a request for admissions is just like it sounds. You're asking the person to basically admit or deny something. And the whole point behind that is to kind of maybe limit. If you guys will go back to Unit 3 where we were introduced to a complaint, and you guys remember how it was broken down, you had like a breach of warranty and what was it? It was like negligence and negligence per se, and it was like 4 or 5 different counts. Well, when you have a complex case like that, when you have any kind of case, you want to narrow the issues as much as possible, but especially in a complex case. Like you say, if you got 5 counts or something, but you realize y'all agree that on 2 or 3 of the things that the defendant is clearly guilty, then that's no longer an issue, and so now we've only got these last two things instead of 5 things to argue before the judge. And when I say you all agree, again, you can kind of get the people on the admit or deny. You do it to each other, meaning the parties do it to each other. You don't send a request for admission or denial to a witness. You can depose a witness, but a request for admission or denial is just between the parties. And like I said, it's just like the name sounds. Admit or deny that you were driving 70 miles per hour. Admit or deny that it was sunny outside. Admit or deny that you were riding behind the defendant too closely or within 5 feet, or whatever you want the question to be. And as I stated, if it becomes an issue later on, when I say later on, when the plaintiff tries to either get the case and say, Your Honor, defendant admitted that they were driving too slow or slammed on their brakes or whatever, so we shouldn't have to have a trial, I clearly win based on the motion. You're going to use that, they admitted in the request for admission or denial, admission number 10 or whatever. And like I say, vice versa, the defendant might use it to say, we sent the other side a request to admit or deny, and the plaintiff admitted that he was only 2 feet behind the defendant, and per the driving regulations, people are supposed to be 5 to 10 feet back, etc., etc. So that's how they come into play, is that, like you say, each side is using some gamesmanship, trying to take that information and then use it to their advantage if they can find something that they think will be helpful to their case. So I'm sorry that the seminar didn't work out. I hope you all find this video beneficial as far as being able to view everything. I will still get on at 3 o'clock in case people don't get this in enough time, but I did want to provide it to you because, as I stated, I know some people like to get their assignments done early. I know I'm one of those people myself. When I was a student, I kind of like to try to get things in a day or two ahead of time just in case something happened. Then I wouldn't be like up to the last minute, just like we had a problem, or I had a problem getting in with the seminar. You don't want to, I didn't want to have to be logging in like 5 minutes till, so to discover that there was an issue. Hopefully next week will be better, and hopefully I can get in and we won't have any issues with the audio or whatever, which is what caused our problem last week. But anyway, I hope you guys have a great week. Feel free to call me, instant message me, email me if you have any questions about the assignment, and I look forward to seeing you next week.